I wanted to record just a quick video on a question that comes up fairly often with injured workers who don't have an attorney. The insurance company has denied the case. They're not paying any benefits. The injured worker sees a qualified medical examiner, and the qualified medical examiner says, yes, there was an industrial injury. That report goes to the carrier, and the carrier takes no further action on it. Several weeks go by, let's say, injured worker, you're still sitting at home, still not receiving treatment, and still not receiving benefits. What do you do in that instance when the QME has come back in your favor and found that the mechanism of injury, what you described, matches the injury that you have? What you need to do at that point is file a declaration of readiness to proceed. There's a copy or a link below this video where you can download that form. And what you want to do is request a mandatory settlement conference. So you may do internet research that shows that you should request a priority conference. That is generally used to address AOE-COE or to address causation. So when the claim is denied and a QME comes back and finds an industrial injury, if the injured worker has an attorney, you would file and request a priority conference. But if an injured worker does not have an attorney, unless you were working for an uninsured employer, they had no insurance company at all, unless that's the case, you can't request a priority conference. You need to request a mandatory settlement conference. So one provision is that on the Declaration of Readiness to Proceed, when you fill that out, you need to make a list of the efforts that you've made to informally resolve the dispute. So you should say the QME examined me, issued his or her report of this date, found an injury, assuming that's the case. You can list any letters or emails that you sent to the adjuster and note that there's been no reply, assuming there hasn't been. Whatever you're going to put down, obviously, is going to be the truth. You're filling out that form under penalty of perjury, so it needs to be accurate. But make a list of the efforts you've made to resolve the dispute, and then mail a copy of that Declaration of Readiness to Proceed to the board. You need to copy that pleading to the adjuster and their attorney, if they have one, so that everyone gets a copy. But then the hearing will get put on calendar. So you'll have an MSC with a judge, and you can explain at that point that the QME found an injury, but the case is still denied. That is generally the best bet when you have a denied case. The QME is in your favor, but the insurance company still isn't accepting your case. So file a DOR, get before a judge, be ready to explain your situation, and if need be ready to set the case for trial, listing your exhibits and witnesses as to what you believe will prove that you did have an industrial injury. Look for other videos that we have on this site further explaining that topic, the pretrial conference statement, on the same channel.